Welcome to Moving Forward Together, Family and Immigration Law Podcast.
Welcome back to Moving Forward Together, Family and Immigration Law Podcast. I'm Lisa Mosbey, and today we're here with attorney Magdalena Wilk of Zuma Law. Magda focuses on family-based immigration and deportation defense, representing clients before multiple federal immigration agencies. As an immigrant herself, she combines personal perspective with years of experience helping individuals and families navigate complex immigration matters. Today, we're talking about recent changes to adjustment of status policy and what families should understand as new uncertainty surrounds certain green card applications. Magda will explain what has changed, who may be affected, and what applicants should know moving forward. Welcome, Magda. Thank you so much for joining me today.
Thank you very much, and witam wszystkich. That's in my Polish native Polish language.
Wonderful. I'm glad to have you here. And Magda, to start, can you explain what adjustment of status is and how someone can use it to apply for a green card without leaving the United States?
Of course. So, adjustment of status, also known as AOS, is the process through which one can obtain lawful permanent residence, most commonly known as a green card, without leaving the country. That is the biggest difference between adjustment of status and consular processing. It was specifically designed by Congress to promote family unity so that individuals who are eligible for it can apply here in the U.S.
And can you tell us who USCIS is? I understand that they recently released new guidance related to adjustment of status cases. At a high level, what has immigration attorneys concerned about this change?
So USCIS, the United States Immigration and Citizenship Service, is the agency that predominantly handles adjustment of status applications and other applications for immigration benefits filed here in the United States. USCIS recently released a memo along with a press release that highlights the discretionary nature of adjustment of status. At a very high level, this memo has immigration attorneys concerned because it gives officers who are reviewing applications more discretion in evaluating some of the negative factors that one might have in their immigration history. For example, overstaying a visa. And when officers have more discretion, that leads to more varied outcomes in the field.
And Magda, one of the biggest concerns surrounding this new policy involves officer discretion, as you mentioned. What does discretion mean in adjustment of status case, and why does it matter here?
So, discretion has always been part of the adjustment of status process. In a way, a balancing test between the positive factors and negative factors. Some of the positive factors could be employment history, strong community ties, U.S. citizen family members, etc. Some of the negatives could be one's criminal history, or in this case, as the memo highlights, overstaying a visa or letting one's lawful status expire and then applying for adjustment of status.
So, what I'm hearing you say is that this new guidance seems to place more scrutiny on visa overstays and expired temporary status. How could those issues now affect certain applicants differently than before?
So, whereas, for example, let's say you have an individual who came to the United States on a work visa, and they decided to overstay that visa. Years later, they meet a U.S. citizen individual who they married. They've now been married. In the past, that adjustment of status process was fairly straightforward and pretty standard. Now, USCIS via this memo is saying that adjustment of status here in the US should really be granted in extraordinary circumstances. And the officer is given more discretion to look into, well, why did the person overstayed? Why didn't they do consular processing? And it opens the door to ask those questions that previously wouldn't even have been asked.
And I know there's been a lot of confusion about whether people now have to leave the United States instead of adjusting status here. What does this policy actually require?
So this is a very important point, and I think this is where a lot of the misinformation is out there because of the press release that came along with the memo. The press release made it sound like everyone has to leave the country in order to obtain a green card and to do consular processing instead of adjustment of status. But that is not what the memo says, and you absolutely should not be leaving the country without consulting with an immigration attorney first. Leaving the country carries very significant immigration consequences, so it's never a decision that you want to make on your own. And even with this memo, adjustment of status under INA Section 245A still stands. Individuals are still eligible. The process might be a little bit different in how the application is evaluated, but individuals absolutely should not be leaving the country.
So, Magda, does this new guidance affect every immigration pathway, or are there certain categories of applicants who are not impacted by these changes?
Yes, so it does not impact everyone. The memo is specific to that it only applies to certain individuals who are eligible under 245A section of the law, meaning other applicants who might qualify under, for example, 245I or asylum applicants who are not who have been granted as asylum and are now eligible for adjustment of status would also not be impacted by this. U visa adjustment, T visa adjustment, special immigrant juvenile status. So there's a wide variety of categories of adjustments of status that are directly related to other sections of the law, that there is an argument that this memorandum does not impact those individuals.
Magda, I'm wondering for families who already have applications pending, could this change affect how their case is reviewed going forward?
So we don't know to what extent USCIS will apply the policy retroactively to applications that have been already submitted. Here in our region, for example, the Chicago field office, after the memo was released, there was information that officers were asking some additional questions related to this memorandum. Now, there's been a lot of backlash surrounding the press release and the memo, and some officers are no longer asking those questions. So there's a lot of inconsistency. There's still a lot of unknowns on how this will be applied, whether that's here in Chicago and Milwaukee or across the country. There's still a lot of we need to figure out, and there's no clear answers how exactly the memo will impact your application. However, if you're not already represented, it'll be a very important time to consider seeking the advice of an immigration attorney, just because the implications if your case is denied are significant.
Magda, let's give folks listening an example of maybe somebody you've worked with who this new guidance applies to. Can you share an example that helps illustrate how a change in immigration policy can affect decisions families are making about their case right now?
Yes. So one would be the one I mentioned would be, for example, if someone entered the United States and overstayed their visa, whether it was a student visa, tourist visa, um, and later on they met a U.S. citizen who they married, and that U.S. citizen is now petitioning for them. They're still eligible to go through the process. However, post this memo, we would evaluate what type of positive equities they can show what kind of answers they can provide for why they overstayed their visa, and why they cannot do consular processing. So while they're still eligible for the benefit, we would do a deeper dive into the types of documents that we would want to prepare, whether it's to submit with the application or potentially submit at a later interview.
And then for families currently planning to apply for a green card, should this policy change, cause them to rethink their plan right away?
Not necessarily. I think families should not panic. Like mentioned, I think there was a lot of misinformation and confusion surrounding the press announcement that came with this memorandum. But as I said before, adjustment of status is still eligible to the individuals that meet the legal requirements for it. You would definitely want to meet with an attorney to evaluate your case to make sure that you are eligible for adjustment of status versus consular processing, and to kind of discuss the potential risks so that no matter what steps you take, you make an informed decision about how you want to proceed.
Excellent. This has been very informative, enlightening, and helpful as you walk us through this guidance. We appreciate your time today. Thank you so much, Magda.
Of course.
That wraps up today's episode of Moving Forward Together, Family and Immigration Law Podcast. To learn more about Magda and the legal services she provides at Zuma Law, visit zumalegal.com. Thank you so much for listening. And don't forget to like, subscribe to the show, and leave a review if you found this episode helpful. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.